everyone! Our educational blog for today is about Republic Act number 7877, also known as Anti-Sexual Harassment Act of 1995, approved February 14, 1995, topic related to crimes against chastity. But before we start with the discussion on the Anti-Sexual Harassment Act of 1995, let us try to know and understand the purpose of the law in our life.
I have read in Magsaysay's Credo that it stated that I believe he who has less in life should have more in law. And based on my understanding to that, those persons na wala kita kayo kagulo sa law, they should be more protected. They should be, like, though we are ignorant, like, I don't really know law school, we should be protected by the law din.
So that's another way to see it. But the literal meaning of less in life, like the workers, mga ordinary workers, the more less ranggo sa workers, the more less pay sa workers, are the ones more protected by the law. Okay, so it is not just those who does not understand the law, it is not just those who don't know the law, understand, doesn't know, it is the workers more protected. It is also indicated there in the Constitution. So that's the protection given by us, by the Constitution and in the legal.
So also Mama stated that sa criminal maxim, it is better that 10 guilty persons go free than that one innocent person be convicted.
Yes, dili ka tuyo kay no?
Yes.
10 guilty persons.
10 versus 1
Versus 1 innocent. So it is better to set free 10 guilty persons. Asa na nga maxim dahil sa?
criminal maxim.
Muna criminal maxims na yun na sa criminal book. Okay. So ako bitaw ng guilty. So grabihan protection kayo. Because the proof required sa criminal is proof beyond reasonable doubt. So if there is doubt, then of course the accused will be set free if there is doubt. So dili siya mag-convicted if the liability of the is under the device of the so yun. So innocenti. So grabe ang pag-protect sa innocent. So understanding nila din besides that.
Understanding na ko ang criminal maxim is kinang dili nag-matter ang idaghan mo sa law, nag-matter ang sa kamatuoran ang truth ma'am which will launch na ang set us free sa Pilipinas. So na promotion of justice, dili injustice mo na ang kanang sa mga kuan sa to ang mindset na ignorance sa law, pero kapag namo na wala mi nag-study og law, no, mga ignorance sa law, so i-erase it siya that law di siya dapat kadlukan but maoy duulan nato kay it protects us kung wala mo tinabot nga any nga pati kaba mo jud sa atong self, so dili ta mahadlok but maduol ta kay sa justice, maduol ta sa law.
Yes, the law practitioners they have high standard. That is why one subject is in relation with sa legal ethics. Nadyo ethics nga i-follow, especially kanang mga practitioners, mga lawyers, mga judge, mga justices. So those people na nag-apply sa law because mga usually mga bright man dyan na di man na nato pili igugol ang law, di naman magani kay may grabe makasabot nga nag-eskwela mi. So muna na ang akong point why we will discuss it, we would like to make a simplified form of the discussion kay why should that kamo nga na protected kitang tanan nga na protected should be aware and should know dili i-complicate ang discussion kay makapalibog. So what's the use of discussing it if we will make it more confusing? So muna nga let us simplify in order for everybody to be able to know the violated rights covered under the Sexual Harassment Act of 1995. So the purpose we're discussing this because it is the topic included, one of the topics included in the Joint Memorandum number 9 series of 2013.
Alright, so now let us try to learn, understand, and know more about the Republic Act number 7877, or also known as Anti-Sexual Harassment Act of 1995. The work, education, or training-related sexual harassment in Section 3, work, education, or training-related sexual harassment is committed by employer, employees, manager, supervisor, agent of the employer, teacher, instructor, professor, coach, or even a trainer, or any other person who, having authority, influence, or moral ascendancy over another in a work or training or education environment, demands, requests, or otherwise requires any sexual favor from that person. So regardless of whether the demand, request, or requirement for submission is accepted by the object of the said
It may be committed by one having authority, influence, or moral ascendancy is exerted. And an education or training environment in particular, the law expressly provides that it may be committed against one who is under the care, custody, or supervision of the offender, or against one whose education, training, apprenticeship, or tutorship is entrusted to the offender.
So, who are the persons punishable? Principal by direct participation, principals by inducement, and principals by indispensable cooperation. Any person who directs or induces another to commit any act of sexual harassment as herein defined, or who cooperates in the commission thereof by another without which it would not have been committed, shall also be held liable under this act. So, the forms of sexual harassment. In some cases, sexual harassment is obvious and may involve an overt action, threat, or reprisals. In other instances, sexual harassment is subtle and indirect with a coercive aspect that is unstated. Some examples include the following. Sexual harassment can occur between persons and equal power status. Example, student to student, staff to staff. Or between persons of unequal power status. Like for example, faculty member to student or coach to student athlete. Although sexual harassment often occurs in the context of the misuse of power by the individual with the greater power, a person who appears to have less or equal power in a relationship can also commit sexual harassment. Sexual harassment can be committed by or against an individual or by or against an organization or group. Sexual harassment can be committed by an acquaintance, a stranger, or people who share a personal, intimate, or sexual relationship. Sexual harassment can occur by or against an individual of any sex, gender, identity, gender expression, or sexual orientation. Examples of behavior that might be considered sexual harassment include but are not limited to unwanted sexual innuendo, proposition, sexual attention, or suggestive comments and gestures, inappropriate humor about sex or gender-specific traits, sexual slurs or derogatory language directed at another person's sexuality, gender identity, sexual orientation, gender expression, insults, and threats based on sex, gender identity, sexual orientation, and gender expression, and other oral, written, or electronic communications of a sexual nature that an individual communicates is unwanted and unwelcome. Written graffiti or the display of distribution of sexual explicit drawings, pictures, or written material sexually charged, name calling, or the circulation, display, or creation of emails, text messages, or websites of a sexual nature. Display or circulation of written materials or pictures degrading to an individual or gender group where such display is not directly related to academic freedom or to an educational, pedagogical, artistic, or work purpose. Unwelcome physical contact or suggestive body language such as touching, patting, pinching, hugging, kissing, or brushing against individuals' body. So, hugging is not a policy because it violates persons' rights. Okay, so physical coercion, pressure of individual to engage in sexual activity or punishment for a refusal to respond or comply with sexual advances. Use of a position of power or authority. 1. Threaten or punish either directly or by implication. For refusing to tolerate harassment, for refusing to submit to sexual activity, or for reporting harassment. Or number 2, promise rewards in return for sexual favors. Acts of verbal, nonverbal, or physical aggression, intimidation, or hostility based on sex or sex stereotyping.
So let us proceed on the duty of the employer or head of office in a work-related education or training environment. Number 1, to prevent or deter the commission of acts of sexual harassment. And number 2, to provide the procedures for the resolution, settlement, or prosecution of acts of sexual harassment. So, letter A, promulgate rules for administrative sanctions. So it means promulgate appropriate rules and regulations in consultation with and jointly approved by the employees or students or trainees through their duly designated representatives, prescribing the procedure for the investigation of sexual harassment cases, the administrative sanctions thereof. Next is to create a committee on decorum and investigation of cases on sexual harassment. So the committee shall conduct meetings, as the case may be, with officers and employees, teachers, instructors, professors, coaches, trainers, and students or trainees to increase understanding and prevent incidents of sexual harassment. It shall also conduct the investigation of alleged cases resulting sexual harassment. And lastly, the employer or head of office, educational or training institution shall disseminate or post a copy of this act for the information of all concerned.
So now, for the liability of the employer, head of office, educational or training institution. The employer or head of office, educational or training institution shall be solidarily liable for damages arising from the acts of sexual harassment committed in the employment, education, or training environment. If the employer or head of office, educational or training institution is informed of such acts by the offended party and no immediate action is taken. We may not be the best person.
We may not have the best knowledge.
Please give allowances to our limitations because what we have is only the best intentions. Once again, we are your Guidance Evening Squad! This is
A place to be you, a place to be real. Your safe place is here.